On Friday, June 21st, the Karen Read trial continued with day 29 of testimony. And on this day, the prosecution finally rested its case in chief.
All right, Mr. Lally.
Thank you, Your Honor. Commonwealth arrest.
All right. So I'm going to stop you right there. A short recess. I don't need one, but...
And at the same time, if you remember from the beginning of these recaps, I mentioned that I might start tracking Adam Lally's use of what, if any, in his questions. Well, I have been tracking, and just a handful of questions into day 29, Lally officially reached 2,000 what, if any's. I also marked the occasion with merch if you're interested. Links are in the description below. Anyway, on day 29, the jury heard from 4 witnesses. Those were Dr. Irini Scordi-Bello, Brian Lucky Laughran, Dr. Marie Russell, and Richard Green. Now that the prosecution has in fact rested its case in chief, I will firmly say that I don't see this case leading to a conviction. I can always be wrong. Sometimes juries will do things that actually really surprise me, and it ends up a learning experience for me. But here, I just don't see it happening. Watch until the end to get my full thoughts on why that is. Let's get into it. Okay, so let's get on to the testimony of the day. If you remember, Dr. Irini Scordi-Bello, the prosecution's 68th witness, did not finish her direct examination at the end of day 28. And this was despite the fact that she had basically given all of her main points on day 28. So starting out the day on day 29, there really wasn't all that much that was new from her testimony, outside of Adam Lally showing the jury the autopsy photos and Dr. Scordi-Bello walking through her findings again, this time with the photos. The other thing that stuck out to me from her direct examination in the morning was also when Lally asked her who she had talked to get information from the investigation to inform her opinion as to the manner of death. And as expected, she did say Trooper Proctor. Lally then asked her whether anyone pressured Dr. Scordi-Bello to come to her conclusions about the manner of death. And she responded, no one pressured me. I am responsible for my findings, etc., etc. And the thing is, I don't know if Lally quite understands the problem around the medical examiner's work and Trooper Proctor's text about it. No one is saying that Dr. Scordi-Bello actually succumbed to pressure from Trooper Proctor in that situation. In fact, Trooper Proctor's frustrated text about the manner of death determination suggests that despite Trooper Proctor's efforts, Dr. Scordi-Bello concluded that the manner of death was undetermined. So the fact that she ultimately came to that particular conclusion was not something that Trooper Proctor wanted. That doesn't mean that he didn't try to pressure her, however. And for her part, Dr. Scordi-Bello said that this was because she's required to come to a conclusion within 90 days of the examination. And she said that by that point, there just wasn't enough evidence to point to any single manner of death. Now, to me, that's still damaging to the prosecution's case. Remember, it apparently took Trooper Proctor all of 16 hours to determine that Karen Read was guilty here. So the medical examiner's professional conclusion stands actually in stark contrast with the Trooper Proctor's assessment, even in just the conclusion about whether or not she could conclude. And ultimately, this is just another way that Trooper Proctor comes out looking unreasonable and unprofessional in comparison. And this also points to the existence of reasonable doubt in this case, which of course helps the defense. Now, despite the fact that on direct exam, the medical examiner's testimony really actually helps the defense more than the prosecution, the defense still managed to score more points here on cross. And the focus here was to call into question the reasonableness of the idea that John O'Keefe's injuries could come from an auto collision. And to do this, Elizabeth Little did a great job of going part by part through the injuries John did and didn't have. For example, on direct examination, Dr. Scordi-Bello had pointed to the fact that Karen's SUV was a taller vehicle, and particularly how the bumper was much taller than, say, a sedan. And the suggestion was that maybe that's the reason why there weren't any injuries to his torso or to his lower extremities, like you would often see in these kinds of cases. So on cross-examination, Little went part by part. There were no injuries to his back. There were no injuries to his pelvis. There were no injuries to his knees. There were no injuries to his shins, his ankles, his wrists, no injuries to his ribs other than what was caused by the CPR attempts. And each time, Dr. Scordi-Bello had to agree. And to put a finer point on it, Little also tied the lack of injuries on John's body to the height of Karen's SUV bumper and taillight. For example, where the bumper or taillight would line up with John's body. There was no significant bruising. There were no fractures. There were no broken bones. And then Little also went through some of the options that could have caused the blunt force trauma to the back of John's head. These were things like a baseball bat or a barbell. Dr. Scordi-Bello agreed those things could do it. And this was, of course, a reference to Brian Albert's basement, which was also hinted throughout trial so far to have had a personal gym in it. But importantly for the defense, Dr. Scordi-Bello also agreed that the force to fracture John's head could have come from multiple blows, not necessarily just a single blunt force. In fact, she even agreed that it was possible that John could have been punched in the face and that he could have fallen backwards as a result and then hit the back of his head on hard pavement as a result. And as to John's arm, Little also pointed out the linear discrete abrasions to John's arm. And Dr. Scordi-Bello agreed that they were both linear and discrete. Patterned was another word that was used to describe them, and that is a word that is also going to come up later during Dr. Marie Russell's testimony. And if you remember, Dr. Marie Russell is the dog bite expert, so keep that one in mind. Anyway, but back to linear and discrete. This is important for a set of abrasions to be discrete because it means that they were individually created. So this calls into question the idea that the abrasions were from road rash, which is what the prosecution originally said that they were at the beginning of this case. That seems to have been changed through Trooper Paul's testimony to maybe those were caused by the taillight shattering, but regardless, all of those options have seemed to have been called into question by the defense. Now, on redirect, Lally tried to refocus the testimony back to the possibilities of the prosecution's case. But this was a really weak redirect in my opinion, and here's why. Lally's questions were basically all, John's injuries could have resulted from this, yeah? They could have resulted from that. For example, he asked, glass and plastic could be a blunt object that could cause this kind of an injury, right? The laceration on the back of O'Keefe's head could have come from striking the ground, right? And the thing is, possibilities are enough for the defense because their goal is to open up reasonable doubt with more reasonable explanations for what may have happened than what the prosecution says it was. But here, the prosecution has the burden of proof. A multiverse of possibilities as to how the SUV killed John just doesn't cut it. That helps the defense, not the prosecution. When you are trying to convince the jury that your way is the way that things actually happened, you need to present a theory with confidence and resolution. And the fact that he could only get the witness on redirect to agree to basically possibilities to explain these things is, in my opinion, a huge problem. Okay, so after Dr. Scordi-Bello was released from her testimony, the Commonwealth rested their case in chief. And as expected, the defense moved to dismiss the charges before the defense was required to put on their case in chief. Now, this is a totally routine thing. It's considered a best practice for any defense team to move to dismiss at this stage. Some would even go so far as to say that it's malpractice not to at least try to dismiss it here. That said, as common as these motions at this stage are, it's just about as common for a judge to deny them. And that's because the defense has an incredibly high standard to meet in order for the judge to grant it. Basically, the defense has to successfully argue that no reasonable jury could possibly convict the defendant based on the facts that were entered into evidence. And so for this analysis, the judge has to look at the facts as entered into evidence in the light most favorable to the non-moving party. In other words, the Commonwealth, and see if there is any possibility that the jury could find in favor of the prosecution. I've said this a lot with past cases, both criminal and civil. The judge is going to look for a single scintilla of evidence, a chinchilla of evidence, if you will, for each element. And if she finds that even a scintilla or a chinchilla checks that box, anything beyond that would be weighing the evidence. For example, was this witness credible, or how likely is it that really this piece of evidence links to this other thing? None of that would be appropriate for the judge to do. That's because it's the job of the jury, not the judge, to weigh the evidence in this case. Our judicial system places a lot of trust and emphasis on the jury system, so judges are going to do basically anything they can not to take this case away from a jury. And here, that's exactly what happened. Alan Jackson argued for the defense that everything in the prosecution's case in chief hinges on Trooper Paul's accident reconstruction, and basically everyone knows that was bogus, and there's no way that a jury can hang their hat on this testimony. Now, he could have argued more, just going down the entire list of things that are wrong with the prosecution's case. But I think honestly, he probably knew of the likelihood of denial of this motion, and so he wanted to preserve the rest of his firepower for closing arguments, rather than giving the prosecution a sneak peek at his closing here. On the other hand, Lally basically threw spaghetti at the wall to see what stuck as he rambled on about the presence of the shoe and the taillight pieces, the accident reconstruction, the medical testimony, the testimony about Karen's alleged admissions, and more. There didn't seem to be much organization to his argument other than to say, look at all this spaghetti. But in the end, the odds were in fact in favor of the prosecution here, and so it wasn't a surprise to me that the motion was dismissed. So with that out of the way, the defense got started with their case in chief. The first defense was Brian Lucky Laughran. And I will say, this guy came across to me as just a pure, salt of the earth, simple man who just wants to go to work each day and do a good job and be a good person and do what's right. He apparently grew up in Canton and has known the Alberts and the McCabe's his whole life. He said he went to elementary school and junior high school with Chris Albert and used to deliver pizzas for a good portion of his 20s for Chris and his pizza shop. He also was a snowplow driver who plowed the snow in front of 34 Fairview Road on January 29th, 2022. Specifically, he said that he passed through there 3 times that morning. The first was about 2:45 a.m. The second time was around 3:15, 3:30. And the final time he said he couldn't quite remember, maybe it was about 3 hours after the second time around, but that his best estimate was it was probably around 5:30 a.m. And each time he would perform his route on Fairview Road, he would drive down Fairview from Cedar Crest, past 34 Fairview on the right, and then essentially turn around at Chapman and go back up the street, this time plowing on the other side. And each time he slowly made his way, aided by very bright headlights, looking for obstacles along the way. And this was very important for his testimony. He said that he has to make it a point to look for obstructions so that he doesn't hit vehicles, pedestrians, or, God forbid, animals. And this was something that I actually found quite endearing about him, as just a little bit of a side note. Of course, he doesn't want to hit a pedestrian or a vehicle, but the emphasis of, God forbid, on animals above all else spoke to a certain kindness that he seems to have. It didn't seem like anything that he was trying to put on, just a subtlety that came across that kind of melted my heart, to be honest. But aside from that part, the more important part here really is how it's part of his job to look for things that are out of place. And he said he never saw John O'Keefe's body there on the front lawn of 34 Fairview Road. He said that his first pass at 2:45 was a normal pass, and he said that he saw nothing. Didn't see John O'Keefe at all. His second pass was at about 3:15, 3:30. Something was different, but still no John O'Keefe body. This time, he said he saw a Ford Edge on the side of the road. Now, this is interesting because there was prior testimony about Brian Albert owning a Ford Edge that he used for work, or maybe using a work vehicle that was a Ford Edge, which he had parked in the driveway earlier that night. And Lucky testified that this time it was right on the side of the road. He said it wasn't there for the first pass through, and he was certain that it was a Ford Edge. He said he remembered this because he had to drive around the vehicle in order to plow the road. And normally, apparently what he's supposed to do is to call in a car that's parked on the side of the road, because residents will get advance notice that there's a snowstorm coming that will require the roads to be clear so that the snowplows can remove the snow. So any cars parked on the side of the road typically are going to get ticketed. However, he said that he chose not to call this in as a favor to the Albert family since he knew that he lived there. Now, this of course can be interpreted in multiple ways. If you view this from the side of the prosecution, you might be skeptical of this answer. It might be a little bit convenient that he didn't call in this detail because it would have served as corroboration of his testimony. However, on the other hand, maybe you view this as someone who wanted to be kind to the Alberts. And so the fact that he's now testifying essentially for the side that is throwing suspicion at the Alberts, maybe this strengthens his credibility, particularly as someone who has to continue to live in the community. Now, at the same time, he did report something in that morning. This was when he personally ran into a basketball hoop that was in front of someone's home. He explained that he could see it. It wasn't that it was not visible to him, but he just miscalculated how far around it he needed to go, so he basically clipped it. And now, from my perspective at least, this does look like someone who doesn't want to get someone else in trouble, but will be the first one to report in on something when he himself did something wrong. This boosts credibility, in my opinion. Anyway, he said that on his third pass through, he saw that there were first responders in front of 34 Fairview Road. And when he tried to come back up 34 Fairview after his turnaround down at Chapman, he couldn't because he said that the entire road was then blocked off. Now, in cross-examination, Lally tried to call into question Lucky's identification of the Ford Edge and his timing for the third pass-through. For the timing, he tried to impeach Lucky by saying something like, "You said third time around that you came to Fairview was 3 hours after the second one. That second one was 3:30 a.m., so your third pass-through was what, 6:30? And the thing is, Lucky had said on direct that he thought that it was about 3 hours after the second, but that he couldn't really remember. And ultimately, he landed on 5:30 as his best estimate. So that isn't exactly accurate math. That's more like 2 hours later, but it's pretty clear what he meant, which was 5:30 a.m. as opposed to 6:30 a.m. So Lally tried to stick this to him, but Lucky was pretty firm in maintaining his testimony. And it looked for a moment like Lally was going to try to impeach Lucky on this somehow. But when he didn't follow this up by presenting Lucky with any receipts showing that Lucky had said otherwise. It just looked like Lally was caught either not listening or otherwise not knowing what he was talking about. And that's the trouble with when you push someone on cross-examination as the attorney who's asking questions. If you don't have the receipts to back up what it is that you are saying when you're pressing on someone by saying that they said something different, you can end up looking foolish as a result if you don't have those receipts. And at the same time, I will also say that when a witness pushes back on cross-examination, there is a way to do it and look evasive, and then there's a way to do it and look confident. I've talked about this with other prosecution witnesses, for example. When Nicole Albert pushed back, she seemed more confident rather than evasive. But then other people from the Alberts and McCabe's looked very differently. And the way that Lucky did it looked confident in what he knew and what he had testified to. Anyway, as I mentioned, Lally also tried to question Lucky's identification of the Ford Edge. He tried to insinuate that when first interviewed about all of this, Lucky at first said that it was a generic SUV that was there, and that it wasn't until someone throughout these interviews essentially placed in his head that it was a Ford Edge. But Lucky was very firm on this. He was respectful and polite, but he was very firm. He said, "Nope. Absolutely not. I knew from the beginning that this was a Ford Edge. That's what I said every single time that I talked about this." And the way that I knew that is because I know what a Ford Edge looks like. And when Lally tried to say that maybe it was a Jeep instead, Lucky said, "Nope, I know the difference between a Ford Edge and a Jeep. The backs of those vehicles look very different. This was a Ford Edge. It was not a Jeep." So in my opinion anyway, this cross-examination was not really all that effective. Okay, on to the defense's second witness, Dr. Marie Russell. If you've been following along, you probably recognize her as the defense dog bite expert that we heard from on day 27 during her voir dire. Her testimony gave the same opinions here in court as they were during the voir dire hearing. She gave her overall opinion that the marks on John's arm were bite and scratch marks due to the pattern of the abrasions or lacerations. And she also said that the marks near the elbow appear to be a bite wound from a large animal, perhaps a dog. She also said that the other marks appear to be claw marks, given how parallel they appear to be. Now, in cross-examination, the prosecution tried a number of things. One of the things that they tried to do was limit the scope of her opinions, although Lally did a very poor job of this, in my opinion. I'm sorry, I know I keep ragging on him, but on cross-examination even, his questions are too long, too vague, and too broad. He tried vaguely to refer to some kind of NAS report, which is something that went undefined throughout this whole testimony, by the way, which indicated that you couldn't line up some bite wounds to a person with a specific dog or something along those lines. He was genuinely hard to follow, and even Dr. Russell, the expert here, had to work her way through to understand what in the world he was talking about. Honestly, Lally was very lucky that she was not a combative or difficult witness, because if she were, he would have had an enormously difficult time getting his point across. But basically, when Dr. Russell figured out what Lally actually meant, she said, "Yeah, you can't line up a particular bite with a specific dog or even a breed of dog, except for a general concept from the size of the bite." And she explained on redirect that this is because a dog can inflict a wide variety of injuries to a person. So it's unreliable to say that this dog's bite will always look like this. Now, Lally also tried to insinuate that Dr. Russell was dishonest about how she got into the case. She had relayed to the jury the same set of facts about her reading an article that came to her inbox about the case in May and how it intrigued her to the extent that she reached out to a colleague about it. And she had previously said during her voir dire that she had had a subscription to the Boston Globe for something like 6 months or a year. But Lally tried to say that she had had that subscription for 18 months. Honestly, what's the difference here between whether she had a subscription to the Boston Globe for 6 months, 12 months, or 18 months? I have no idea. I don't see how he was trying to catch her with this because it doesn't seem to matter anyway. But again, this was Lally looking like he was trying to impeach a witness and coming up short when it came time to show receipts and back up his impeachment. So once again, like what happened with Lucky, it looked like Lally did not know what he was talking about. Anyway, before we move on to the final witness of the day, there was one more thing that Lally asked Dr. Russell about on cross-examination. And this was about her conclusion. He basically asked, "It's your opinion that this is a dog bite. Is that to the exclusion of all other possibilities of what could have caused that?" And Dr. Russell answered, "Well, yeah." Now, I have to say, I don't understand a lot of what Lally has done in this trial. And this is one example. Lally specifically tried to limit Dr. Russell's testimony through the voir dire hearing, and Judge Cannone actually did in fact limit it. She said Dr. Russell could say that this was a bite mark, but that she couldn't say that this wasn't caused by other things. I've talked about this expressly in other recaps. Now, I personally disagreed with that because I thought Dr. Russell had the requisite education, experience, and expertise to come to that conclusion, and because I think that it's a necessary part of the diagnosis process is ruling out other possibilities. But here we have a win that Lally got because Dr. Russell wasn't allowed to testify to that on direct, and then he goes and asks her specifically to testify about that on cross-examination. This is the definition of snatching defeat from the jaws of victory. I don't know what his strategy or plan is with this, or if he was even really thinking, but here we are, I guess. Anyway, the final witness of the day was the state's third witness, Richard Green. Green is a digital forensics expert, and his testimony was intended to combat the testimonies of Jessica Hyde, Ian Whiffen, and Trooper Guarino. Overall, he was another witness who I just would love to have at my Thanksgiving dinner table. He was kind, he was affable, he just seemed like he was excited to be there to talk about the stuff that he loves to do and that he loves to talk about. He said he's from Michigan, and he definitely had the Midwest-friendly vibe for sure. He basically testified about three things. It was Jennifer McCabe's alleged 2:27 a.m. Google search, the health data on John O'Keefe's phone, and the location data on John's phone. In a nutshell, here's what Green said about each of these. For the Haas Long to Die in the Cold search, Green said that the Celebrate report did in fact relate the time of the entry to the actual search. He said that the browser state DB wall was in fact a data source that relates to tab movement and tab functioning. However, he expressed that the iOS updates over time are important because they change what shows up in these Celebrate reports as well as how they appear over time. And there was some indication about this in Ian Whiffen's testimony before, but I remember being somewhat frustrated in Whiffen's testimony about this point. He kept saying it could depend on which version of iOS is on the phone, but if I remember correctly, he never clarified what version of iOS was on John's phone. But here, Green said, because of both the kind of iPhone that John had and the version of iOS that was on his phone, this Celebrate report entry indicated that the 2:27 a.m. timestamp related to the search, not the tab movement. I will say he was very confident and his testimony was actually fairly clear, especially in comparison to the other two experts. However, everything about the Haas Long to Die in the Cold search at this point has been super technical and super complex. In order to get to the bottom of it, you really have to spend a lot of brain calories unless you are already very tech savvy. Given that I personally am not, by the end of Green's testimony, I felt like, okay, maybe Jen did make that search at 2:27 a.m. And previously, I was fairly convinced by Jessica Hyde's testimony after I was able to really sit with it for a while. But here's the thing. When something is very complex and difficult to understand, but at the same time, not a central question of the case, the jury may just look at all of this testimony in front of them and go, I have no idea which way is right. And at this point, I don't really care. And I'll be honest about this particular point and this particular question, I'm kind of feeling that personally. Maybe someone on the jury is dead set either way. Or maybe someone is very experienced in tech to understand better what's going on, and maybe they have a better opinion. If that's the case, that can influence the other jurors in the deliberation room who may have been feeling a little wishy-washy about that whole question either way. But because it's not a central question in the case, the jury can also kind of disregard the issue and just focus on the main questions and come away with a proper conclusion nonetheless. And I have a feeling they may end up doing that on this particular issue. Okay, so let's talk about the other two topics that Green covered. Those basically respond to Trooper Guarino's testimony. And this was about the health data and the GPS location data. The health data was talking about the steps and the stairs count that John's phone allegedly measured between like 12:11 a.m. and like 12:32 a.m. or something like that. Trooper Guarino had basically said that all of this could be disregarded as essentially inaccurate, at the very least because the timing of the stairs count lined up with the exact time that John's Waze navigation app placed him all the way over on Oakdale on the way to 34 Fairview Road. Essentially, if he was sitting in a car, he couldn't have been walking up and down the stairs. But Green said that based on the testing that has been done on Apple Health data, these measurements like steps and stair counts are considered to be about 98% accurate. And when pressed about this on cross-examination, he told Lally that no, the same is not true about GPS location data coming from iPhones. In fact, GPS data with respect to iPhones is generally not very reliable, he said, in part because it has to draw from connection sources like Wi-Fi networks that it passes by, as well as cell phone towers that can be totally hit or miss. And looking back at the health data, remember on cross-examination, David Giannetti made this point about the 3 different clocks that are on an iPhone. Those were the monotonic clock, the baseband clock, and the wall clock. And here, Green testified about finding through an update of one of his data analysis tools that these apps will link up with a specific clock sometimes. And specifically, he said that he found that John O'Keefe's Waze app linked up with the monotonic clock. And when they showed the jury what this all looked like in the analysis report, recording, you could see that there was a slight difference between the baseband clock and the wall clock. They were about 2 seconds off from one another, but the monotonic clock was almost exactly 3 minutes off. So there's a possibility here that when Waze said that John was over in Oakdale at 12:22 a.m., he may have in actuality been there at 12:19 a.m. Now, Green clarified that he couldn't be totally conclusive about this, but he said that it opens up some questions about the accuracy of the Waze timestamp. And Green also said that normally this doesn't make a huge difference in the forensics cases that he does. However, in a case like this, minutes appear to matter quite a bit, so he wanted to highlight that. And that's true. In this specific instance, those 3 minutes can in fact mean the difference between John being in the car on the way to 34 Fairview Road or being at 34 Fairview Road and specifically inside the house. And although he couldn't come to a more firm conclusion about this data, remember, for the defense, that is enough. They don't need to prove anything in this case. They just need to introduce enough reasonable doubt so that the jury says that there are too many open questions about important things to be able to convict. Now, on cross-examination, Lally tried to poke holes in this testimony, but I don't see how he was terribly successful at it. For one thing, every time Lally would try to press Green on a point, Green would take it as an opportunity to confidently restate his opinion. For example, Lally asked about the reliability of the steps counter. And in response, Green said, well, actually, I even tried to test it on the same model phone by waving it in the air and by going up and down with it in the air and even clipping it to a belt and doing all kinds of stuff. But I found, even anecdotally, that this was all totally accurate. And then when Lally asked about the reliability of native GPS tracking on a phone, Green again pushed back. He reiterated that a GPS signal on a phone relies on crowdsourcing from local Wi-Fi networks, cell towers, and more. And when Lally said, okay, but Waze placed John elsewhere when you said he was on the stairs, Green even responded, yeah, but the monotonic clock issue. Now, another thing about Lally's cross in general, there was the same issue here as always with his long-winded, disorganized questions that are just hard to follow. And like with Dr. Russell, Lally had a defense expert on the stand who was listening intently to his questions and genuinely confused about what Lally was even saying. And again, Lally lucked out that this expert was not combative, and he literally said something like, hey, I'm sorry, I'm trying to answer your questions, but I just don't follow it. And one other thing that I'll note about the overall tone and impressions when coming across to a jury. There is a way to do a good, spicy cross-examination. I love a good, spicy cross-examination. I've been talking about the defense's crosses this whole trial, and particularly Alan Jackson's style. Not everyone loves his style, but personally I do. There have been a few times that I thought both Jackson and Yannetti have gotten a little bit caught up in their frustrations with the witness, and it's made me cringe a little bit. But overall, the spice that they've brought has been kind of a delight to watch. But for some reason, Lally was not coming across the same way here with this witness and with the other witnesses before him. He seemed bitter and angry and almost like all of this was kind of personal to him. And I think the problem for Lally is that there's a missing ingredient here. It's charisma. It's connection with the witness. You see, even when getting a little spicy on cross with a witness, Yannetti and Jackson would still often find a way to connect with them. For example, remember how Alan Jackson was cross-examining one of the paramedics who had a very Bostonian accent. And Jackson, being from LA, had a moment where he was genuinely like, I have no idea what word you're using. And then there was this realization of like, oh, that's what you're saying. And the witness was like, sorry, that's my accent. But then Jackson in response said something like, oh, no. I'm the outsider here. Everyone laughed, including the witness. That's charisma. That's connecting with a witness. And that is the kind of thing that is going to endear an attorney to the jury, especially if that kind of personality continues to show throughout the trial. But the difference with Lally here is basically all of his cross-examinations on day 29 came across as him not being spicy, but bitter. It was almost as if he was thinking, I shouldn't even have to be cross-examining you. You shouldn't even be here. And maybe it's just me, but this apparent bitterness seemed to get worse and worse as the day wore on. And in juxtaposition with all three of the defense's witnesses so far, who were firm, but also polite and friendly, and often seemingly trying to be helpful, it also made Lally look pretty bad in comparison, I think. Then again, maybe my personal impressions have just been a little bit skewed about Lally, since in the middle of the cross-examination of Richard Green, I caught him in something that was a very dirty, slight move. Remember how I got really fired up on day 28 about the prosecution's attempt to bring in Karen Reed's alleged Google search for a DUI attorney at like 1:27 p.m. on January 29th, 2022? I was especially upset that the prosecution was even trying to insinuate that hiring a lawyer or even looking for a lawyer was evidence of consciousness of guilt. And thankfully, Judge Cannone denied the prosecution's request to enter this into evidence because it was way more prejudicial than probative. In fact, it's not probative at all. However, the dirty bastard tried to sneak it in nonetheless. It was so sneaky that I'm not even certain that the defense team even caught it in the moment. You see, during his cross of Richard Green, Lally asked a bunch of boring questions about location data. And then all of a sudden, he asked about whether he looked into a Google search by the defendant from the afternoon of January 29th, 2022.
Now, with respect to the defendant's phone, did you also find deleted web history data from the afternoon of January 29th, 2022?
No, I'm sorry, I didn't observe that.
Didn't observe it, or didn't look for
it? I really don't have a recollection if I specifically looked for deleted data. I don't believe I did. I don't know if I would have had to have a cause to.
Now, right after this exchange, Lally went right back to asking about location data, indicating that he really was trying to sneak this Google search testimony in under the radar after he was expressly told by the judge that he couldn't do that. I was surprised that Irini didn't object to this, but then again, the jury may not have been paying attention due to the boring nature of the questions leading up to them. So maybe the lack of an objection wasn't because he didn't notice, but because it was more strategic. Why wake up the jury to something if they're already not paying attention? But either way, this is a freaking dirty move by the prosecution. I was upset that he even tried this in the first place. But now trying to sneak it in between questions about an entirely different topic when he was expressly told that he couldn't ask about this, that just feels like a very scummy move. And it informs a very different opinion that I personally have about Lally's ethics as an attorney and as a prosecutor. This is not what prosecutors are supposed to be like. They're supposed to be in pursuit of justice, not convictions, and so there is no place for moves like that in any case. The jury wouldn't have seen or noticed any of this, of course, so it's not going to make an impression on them about the case. For me personally, the way that I view Lally and the DA's office is I just don't like what I see here. But anyway, looking at the day as a whole, all in all, I think that the defense had a very strong start to their case in chief on Friday. After court let out, the defense told the media that they have just 3 more witnesses apparently, and they anticipate getting through all of them on Monday. That would mean closing arguments would be on Tuesday, and like Judge Canone promised the jury, they can start deliberations next week, and I anticipate that we'll have a verdict well before Friday. But those are my thoughts. What do you think? Do you think that the today's testimony was strong for the defense? What do you think about Jen McCabe's 2:27 a.m. Google search about Hoslong to die in the cold? What about the dog bite testimony? And what about Lucky Laughran, the snowplow driver? Let us know in the comments down below. Otherwise, I hope you enjoyed this or at least found it interesting or informative. And if you did, I would love it if you could hit the like button. It does help us with the YouTube algorithm gods. And if you're new here and you want to see more of the Karen Read trial coverage, both in daily recaps and in live gavel to gavel coverage, be sure to hit the subscribe button and the notification bell so you can find out when the next video is out there. And if you really want to support the content, consider becoming a member of Byte Club. You can join either through YouTube memberships or by supporting on Patreon, and doing so means that over the long term of this channel, we can continue to devote intensive resources to trials like this one and other interesting legal topics. Links to both are in the description below. Otherwise, see you on day 30.